Good morning. I'm Dwight Keene. I'm chair of the Kansas Corporation Commission. I'm joined this morning by fellow Commissioner Susan Duffy and Commissioner Andrew French. At this time, I'm convening this hearing on Thursday, August 4th, 2022 at 10:30 a.m. via Zoom on the settlement agreement in the matter of the application of Kansas Gas Service Company, a division of One Gas, Inc., for the recovery of qualified extraordinary costs and the issuance of a financing order pursuant to and under docket number 22-KGSG-446-TAR. We are conducting this hearing by Zoom and broadcasting to the public on YouTube. Please bear with us if you experience technical glitches. Let's first turn this morning to the entries of appearance, and I'll begin with KGS.
Good morning, Your Honor. Robert Vincent and Jim Flaherty appearing on behalf of Kansas Gas Service, a division of One Gas Incorporated.
Thank you, Robert. Curb.
Good morning. This is David Nickel. I appear along with Todd Love and Joseph Astrab on behalf of the Citizens Utility Ratepayer Board.
Good morning, David. The KCC staff. KCC staff, entry of appearance.
Good morning. This is Carly Massentine entering my appearance on behalf of staff along with Michael Neely and Charles Watson.
Very good. Thank you, Carly. Does the staff have a recommendation regarding notice?
Yes, Commissioner, I apologize. Staff has examined notice in this matter and reports that on April 28th, 2022, the Commission issued an order granting staff's motion for procedural schedule, setting a hearing in this matter for August 3rd through the 5th, 2022, beginning at 9 a.m. On July 27th, 2022, the presiding officer amended the schedule to convert the hearing to a one-day hearing on the proposed settlement agreement, starting at 10:30 a.m. on August 4th, 2022. Therefore, staff recommends a finding of proper notice for this hearing.
Very well. Are there any objections to notice? Hearing none, I find that notice is proper and that the Commission has jurisdiction over this proceeding at this time and place. Before we turn to preliminary matters, let's review a few matters incidental to conducting a hearing via Zoom. We're getting pretty accustomed to this process here, so I will really abbreviate this explanation. First, if any party encounters any technical issue today, please ask to go off the record so that we may resolve the technical issues off the record. Second, all witnesses participating by Zoom are asked to keep their microphones off until they are scheduled to speak. And third, if the Commission needs to deliberate, we will be going off the record into a breakout room, entering into a Zoom breakout room where you can't see or hear us, and then we will return after that is concluded. I understand the parties may wish to admit pre-filed testimony into the record. Is this correct?
Yes, that's correct, Your Honor.
Is that Robert?
Yes, sir.
Yeah, please proceed.
At this time, Kansas Gas Service would ask and request that the pre-filed direct testimony of Janet Buchanan, Mark Smith, and Charles Atkins be admitted into the record. We would also ask that the rebuttal and responsive testimony of Ms. Buchanan and Mr. Smith be admitted into the record as well. I should note that both Ms. Buchanan and Mr. Smith supplied updated direct testimony in June of this year. We would also ask that that testimony be admitted into the record. Finally, Ms. Buchanan submitted two erratas in the docket, and we would ask that that be admitted into the record at this time. We'll ask for Ms. Buchanan's testimony on the settlement to be admitted when she takes the stand this morning.
Very well. Are there any objection to any of these matters? Hearing none, they are admitted. Any other parties wishing to admit pre-filed testimony into the record at this time?
May it please the commission, this is David Nickel on behalf of CURB, and I would ask for admission of the pre-filed testimony of Patrick Orr. At this time, Patrick Orr will testify in support of the settlement agreement. We will ask for admission of that particular aspect of his testimony when we put him on the stand. But as to the former testimony and with regard to this matter, we would ask for admission of that pre-filed testimony.
Is there any objection? Without objection, it's admitted. Does the staff wish to admit or request the admission of pre-filed testimony at this time? Does the KCC staff wish to? Yes, Charles? I just turned to you because your microphone is on.
I've left it on, but Mr. Neely was going to do the admission, but I can, and I just don't have the date in front of me, but I move that Mr. Grady's testimony with direct testimony that was filed in this docket, that it be admitted, and that his testimony in support of the settlement will be offered at the time of his in-person testimony.
Yes, that's correct.
And what was the date on that, Michael? For the record.
It was June 17th.
June 17th for his direct.
All right, thank you. Is there any objection to the admission? Without objection, it's admitted. Are there any other preliminary matters any of the parties wish that we address at this time?
Again, may it please the commission, this is David Nickel on behalf of CURB. We would move for a waiver of the post-hearing briefs in this matter. This matter is non-unanimous settlement agreement. We don't believe that the briefs will add very much with regard to this matter beyond what has already been filed in the testimony in support of this agreement. And then in terms of the volatility of the market, the quicker that we can get approval from the commission of this matter, I think is beneficial to the ratepayers and the company in this case. So we believe there's reason for waiving these post-hearing briefs at this time, and we request the commission to do the same.
Very well. Is there any objection to this motion? Motion's granted, and we will, according to the request, without objection, waive the post-hearing briefs. We have been advised before the proceeding that it was your intention as well to request that the commission expedite the order in this docket. And with respect to that latter request, we will certainly take administrative notice of that request. Any further preliminary matters to come before the commission? All right. Very well. Let's discuss the procedure for this hearing. The parties will make opening statements. KGS will go first, followed by CURB, and then the KCC staff. After opening statements, we will follow the order of witnesses agreed to in the pre-hearing conference. I also understand that at the pre-hearing conference, the parties indicated that they will not make closing statements, and we've just addressed the issue of post-hearing briefs. Let's turn now to opening statements. I'll turn first to KGS. Mr. Benson.
Thank you, Chair Keen. I'll go ahead and share my screen. And if you would let me know if you're able to see it.
We can see it. Thank you.
Thank you, sir. Chair Keen, Commissioner Duffy, Commissioner French, good morning. It is my distinct pleasure to appear before you and present a unanimous settlement agreement reached in Kansas Gas Services securitization docket. Today is an exciting day, and we are incredibly proud, not only of this agreement and what it signifies, but of the tremendous amount of work that went into creating it. KGS, staff, and CURB have been laser focused on one goal: minimizing the financial impact of Winter Storm Uri on our customers. The agreement and proposed financing order before you achieves this goal. Today represents a milestone for our customers, and I'm eager to take you through this agreement. Now we've got some ground to cover, so let me dive right in. The agreement is comprehensive. It provides for significant regulatory oversight, delivers real savings for our customers, and memorializes key commitments between stakeholders. Securitization can provide remarkable benefits to ratepayers. We ensure these benefits through collaboration, and that starts with the Commission's oversight. The designated representative is a statutorily required member of Commission staff who advises the Commission. Supported by financial and legal advisors, the designated representative is instrumental to ensuring our securitization is a success, and the settlement outlines their roles and responsibilities. Throughout the securitization process, there are two essential and competing interests. First is the need to act. Our company needs to react quickly to questions from investors, meet with ratings agencies, and get ahead of dynamic financial markets. At the same time, there's a need to review. Kansas's securitization law has certain statutory objectives, and the designated representative needs access to information. To achieve this, we've created a collaborative two-part framework with a pre-issuance review plus the issuance advice letter process. This is a comprehensive process. It covers all facets of the securitization and gives the designated representative the ability to observe, review, confer, and consult on all facets of it. That includes the material terms related to bond structuring, marketing, pricing, and issuance. It also contemplates and coordinates access to critical meetings between the company and third parties, all while recognizing Kansas Gas Service will lead the securitization transaction. The settlement before you refers to the designated representative nearly 50 times. In fact, every settlement term tied directly to the securitization process incorporates the designated representative's review. We recognize Commission oversight is a key part of the securitization process. That's why oversight is built right into this agreement. Every bit as critical as oversight, though, are the savings our customers can expect. Securitization minimizes cost to customers by using low-cost financing from ratepayer-backed bonds. This financing can deliver real savings. Recovering Winter Storm Uri's costs through traditional rate making would place a heavy burden on our customers. By accessing this financing and extending the recovery term, we can deliver real rate relief. And even though we've extended the terms of these charges, customers still benefit. That's because this financing provided through securitization generates tens of millions of dollars in savings. Compare the net present value of traditional rate making against several different securitization options. Securitization ratchets up customer savings. Now, there's no magic formula for selecting the best securitization term. It's a mix of bill income impacts, savings, and customer equity. But viewed through this lens, and weighing those interests, the settlement agreement before you identifies a term of 7 to 10 years as one that strikes the best balance of customer impacts and savings. It's a unique agreement here because it provides flexibility, but that's not all. We're also requesting the Commission issue two separate orders, one approving the settlement and the other approving the financing order. We need two orders because the agreement involves more than just securitization. The settlement agreement is remarkably broad. It approves and endorses our request to move forward with securitization, but it also approves the tariffs necessary to recover our extraordinary costs. In addition, certain portions of our general terms and conditions need to be waived, so the securitization payments get payment priority. At a policy level, we agree to study rate design options for our residential customers and potentially engage in generic investigations. There are many key commitments outlined in this agreement. Contrast that, though, with the proposed financing order, which has a surgical focus, and that's the bond issuance. This order outlines the responsibilities our company will undertake in servicing and administering this process and contains several required transaction documents. There's a significant amount of information to digest in these documents, and that's why we built both with a set of common terms. Key elements of the settlement agreement, like the role of the designated representative, are found right in the financing order. And as I'll highlight in a moment, These agreements meet the Commission's rigorous settlement standards and satisfy Kansas's securitization law. Now that we've covered the agreement's provisions on Commission oversight, ratepayer savings, and unique features, I'd like to walk through the other terms and commitments contained in the settlement. First is the ability to recover qualified extraordinary costs from our customers. We'll use securitization to recover just over $328 million from our retail customers using a fixed monthly fee. This will vary depending on customer class and will be subject to a final review during the issuance advice letter process. Our resale customers will pay for their costs using traditional rate making, and this is a great example why we need two orders. Securitization is permitted for retail customers, but we can't recover costs from wholesale customers with a financing order. These costs will be recovered using a volumetric rate over about 5 years. Next are the net quantifiable benefits our customers can expect, and those range in the tens of millions of dollars, $35 to $46 million, depending on the term of the securitization. And like the costs, they'll be subject to the issuance advice letter process and its review. The agreement targets a final maturity of 7 to 10 years for this bond issuance and provides flexibility needed to achieve a AAA rating. We also discuss the important distinction between the bond's final scheduled maturity and its legal maturity. There are several documents that need to be executed for our transaction to move forward. The agreement before you requests approval of these documents as to their form ensures they'll be filed once they're executed, all while being subject to the designated representative's review. The parties agree on the tariff we'll use to recover our extraordinary costs from retail customers. This settlement establishes how these costs will be allocated, outlines that the methodology we're using is appropriate, and contains an adjustment mechanism to help secure the highest possible bond ratings and ensure the bond's principal and interest is always paid on time. There's a settlement fee that applies to sales customers who switch to transportation service while our winter storm Uri recovery cost rider is in effect. The fee is calculated using the net present value of the customer's remaining obligations and is based on the weighted interest rate the bonds receive. We recognize there'll be a difference between the final amount of the bond issuance and the total qualified and extraordinary costs our company incurred. That difference will be reconciled through the reconciliation process, where any difference between these two will be credited or charged to our customers through our cost of gas rider. Kansas Gas Service will perform and be compensated for several services provided to the special purpose entity created as part of the securitization process. We've outlined a procedure for tracking and addressing potential differences in incremental costs if the cost is less than what the company has paid. That will be addressed during our next rate case. The agreement makes clear how Kansas Gas Service is compensated for its equity contribution and how ratepayers are compensated for this contribution's investment earnings. Kansas Gas Service will earn a return on its equity contribution at its weighted average cost of capital. And using the adjustment mechanism contained in the WESCR, ratepayers will benefit from any additional investment earnings on this amount. On customer education, the parties agreed to use the plan presented by Kansas Gas Service and will work together to finalize the specifics of it in the coming weeks. The settlement agreement seeks permission to waive a portion of Kansas Gas Service's general terms and conditions. Again, this recognizes the need for payment priority, so the first dollars we receive go to paying the bond's principal and interest. Given the nature of the settlement agreement, the proposed financing order, the parties agree that the financing order should control if there are any inconsistencies. During our next rate case, Kansas Gas Service will present a study of its residential class. We'll outline whether residential customers could benefit by splitting into multiple subclasses, similar to how one gas classes are structured in other jurisdictions. The agreement contains a commitment to work together on a generic investigation into energy burden. There are a few preconditions necessary to this, including some action from the Kansas legislature. But assuming those are met, the agreement sets out a path for evaluating a low-income tariff. The settlement and its commitments are the result of extensive collaboration between the parties, and I'd like to expand on that briefly. We hosted a series of technical conferences where we could sit down and talk with each other and have expert-to-expert collaboration. This allowed us to share ideas, receive critical feedback, review financial projections, and when the time was right, shared drafts of the proposed documents before you today. The settlement achieved in this proceeding is the product of differing interests and perspectives working towards a common goal. We very much appreciate staff and CURB's willingness to engage with such intensity. Now that we've touched base on what's in the agreement, I'd like to briefly discuss the legal requirements this proceeding is subject to. And first up are the Commission's settlement factors. The Commission typically applies 5 factors when evaluating settlements. For unanimous settlements, only 3 factors are required. That's because parties have had an opportunity to be heard on the agreement already. Ms. Buchanan will testify on the significant amount of substantial competent evidence that this record contains and why it is fully appropriate for the Commission to endorse, adopt, and issue the proposed financing order. She'll also testify on how the resulting financing order and its rate impacts are just and reasonable. Finally, she'll elaborate on why approving the settlement agreement and the financing order is in the public interest. But that's not all. We need to ensure that the settlement that we do believe meets the Commission's settlement factors also is consistent and meets Kansas's securitization law. There are several elements of a financing order that need to be met. As we walk through the agreement today, we covered how the agreement outlines the amount to be securitized, the net quantifiable rate benefits our customers can expect, how we'll mitigate rate impacts, the customer education plan, the adjustment mechanism, and the issuance advice letter. What we did is we took Kansas's securitization law and used it as a template for creating our financing order before you. That way, we know it contains every element and fully satisfies Kansas's securitization law. As we wrap up our walkthrough of the agreement, I'd like to leave you with a few concluding remarks as to why this agreement benefits the public interest. As a settlement, it meets the Commission's settlement factors. As a financing order, it satisfies Kansas's securitization law. From a regulatory perspective, it buttresses the Commission's oversight. For our ratepayers, it delivers real savings. And most importantly, this settlement minimizes the financial impact of Winter Storm Uri on our customers. I want you to take a moment and think back to February of 2021. We talk about this time period frequently and mention Winter Storm Uri by name often. I want you to remember how cold it was. I want you to remember all the phone calls that were made, the public appeals, the energy emergencies. I want you to remember the press conferences and the emergency order issued by this commission. Winter Storm Uri was a serious, life-threatening event. This commission gave us the tools necessary to ride through the storm and charged us with an impressive responsibility that when the story of Winter Storm Uri is told, it ends with minimal financial impact to our ratepayers. The settlement agreement before you today writes that ending. We are incredibly proud of this agreement because it represents the best of all our efforts, and we look forward to testifying in support of it today. Thank you.
Thank you, Robert. All right, very good. Next opening statement will be on behalf of CURB, David Nickel.
Good morning. My name is David Nickel, and I'm speaking on behalf of the Citizens Utility Ratepayer Board, known as CURB. May it please the Commission. CURB intervened in this docket to ensure that the interest of Kansas residential and small commercial ratepayers were observed relative to the issue of securitization of Winter Storm Uri cost. In this case, as in all rate cases, CURB was skeptical that the amounts KGS proposed to charge Kansas ratepayers are just and reasonable. The interest of residential ratepayers are often opposed to utility interest, and CURB will consistently oppose proposals that are not in the ratepayers' interest. CURB's role in this case is no different than in other cases. One question that particularly troubled CURB in this docket is how could it ever be in the interest of residential ratepayers to allow KGS to recover from them the cost of natural gas, which exceeded $600 per MCF during Winter Storm Uri? I would like to take a moment to address how that question affected CURB's view of this docket. In the case of Winter Storm Uri, the predominant interest of residential and small commercial ratepayers was continuous service during the storm at reasonable cost. In CURB's view, reliability of service at reasonable cost, even in extreme circumstances, was not only ordered by the Commission, but it is part of the regulatory covenant established by Kansas statute. Whether KGS satisfactorily met its regulatory obligations involves the prudency standard. CURB reviewed KGS's actions in connection with Winter Storm Uri under that standard. For the reasons I will describe, CURB believes that KGS met its regulatory obligations in this case. To start with, in accordance with the Commission's order, KGS was able to maintain continuous service in over 99% of its service territory during the entire winter storm. However, it was at a very high cost. KGS bought gas at extremely high prices. Were those purchases imprudent? If so, KGS should bear those imprudent costs. The prudency standard asks, what would a reasonable utility do under the circumstances? Regarding that question, no party offered proof that KGS's payment of high gas cost to maintain reliability during Winter Storm Uri was imprudent. Indeed, gas costs were high throughout the Midwest. In fact, other gas utilities in Missouri, Arkansas, Iowa, and Oklahoma, and other states were forced to bear high prices to maintain service to their customers, just like in Kansas. Given the similar circumstances of so many gas utilities, CURB cannot assert that KGS stands apart or that all of those gas utilities were imprudent. But is it reasonable to force KGS customers to pay for natural gas at $600 per MCF merely because that is what the market will bear? When gas prices go from $3 per MCF to $600 per MCF and then retreat back to $3 all in a matter of days, it is hard to believe that natural gas production and transportation cost increased and decreased that rapidly. In CURB's view, it is likely that someone in the supply chain profiteered due to that emergency. That, if it occurred, is illegal profiteering, and those ill-begotten profits need to be returned to ratepayers, period. But CURB recognized that KGS did not cause these high prices. KGS was a price taker, not a price setter. And the dilemma that KGS faced is clear. Should it pay high natural gas prices and keep its system running? Or should it not buy gas because the price was too high and curtail customers' usage, possibly resulting in property damage or death, as occurred in Texas? The evidence shows that KGS's decisions in this matter were prudent under the circumstances it faced during Winter Storm Uri. Therefore, it would be unlawful and unreasonable to require KGS to pay natural gas costs, which it necessarily incurred to maintain reliability during the winter storm. Nor is it in the public interest to require KGS to carry the high gas cost until profiteering is or is not determined to have occurred. That could be years. Accordingly, the KCC required KGS to guarantee that any disgorgement of unlawful profits obtained from suppliers would be returned to ratepayers. In the interim, the parties here believe that securitized recovery of extraordinary fuel cost is in the public interest. In CURB's view, it would be entirely appropriate for the Commission to approve securitized recovery in this docket, notwithstanding the fact that the issue of profiteering remains unresolved. The KCC does not have jurisdiction over interstate suppliers of natural of natural gas prices. The KCC has no authority to dictate what natural gas prices should be or to disgorge unreasonable profits from natural gas suppliers. Those responsibilities belong to FERC, the Kansas Attorney General's Office, and to private consumers. Nevertheless, we cannot stay comfortably in our lanes and do nothing. We must all actively insist that those that have authority to protect ratepayers from unreasonable gas prices do their jobs, and we must support those agencies the best we can. In short, our jobs do not end with this docket. All of us, including KGS, must remain vigilant and help ensure that any profits due to price gouging are returned to customers. I know the Commission will do its part. For CURB's part, we pledge today to continue to use any influence that we have to require that the issue of profiteering be quickly and fairly resolved. CURB has already been engaging with other consumer advocate agencies in various states to learn what is being done in other states on this issue. In this and other associate dockets, CURB has sought to obtain legislative and other relief for low-income consumers who are the most adversely affected by high gas prices. CURB is aware that high natural gas prices charged to consumer during Winter Storm Uri has high public interest and has been covered by the press. In Kansas, we are fortunate to have a press that is keenly aware of Kansas ratepayers' need for reasonable energy prices. On the occasions that we have talked to Kansas news reporters, we have been impressed by their intelligence, thoughtful questions, and their passion on this issue. More importantly, CURB feels that keeping sunlight on any profiteering that may occur is helpful to residential consumers. This issue notwithstanding, CURB believes that securitized recovery in this case is in the public interest. It is true that CURB offered testimony supporting recovery through volumetric charges versus high fixed charges. CURB witness Patrick Orr will explain CURB's position. However, in this particular case, we are informed that a volumetric charge to recover extraordinary fuel cost would obviate securitized recovery. We believe that securitized recovery will result in the lowest financial cost in the recovery of qualified extraordinary cost, and it complies with the Commission's direction to minimize cost. Therefore, Mr. Orr will testify that CURB agrees to the fixed charge in this particular case as being in the public interest. In addition, subject to CURB's remarks regarding profiteering that may have occurred and the need to disgorge those unlawful profits if there are any, the low carrying charges offered by securitization will help maintain as low of recovery rates as possible. Mr. Orr will testify as to the net quantifiable benefits posed by the approval of the unanimous settlement agreement. Therefore, the evidence supports the position of the settling parties that securitized recovery results in just and reasonable rates. Finally, there is substantial and competent evidence in the record from the KCC staff, CURB, and KGS, which together support all required findings on the pertinent statute. Therefore, the elements necessary for the Commission to approve the unanimous settlement agreement in this matter are present, and CURB recommends such approval. One other aspect of this settlement agreement that makes it reasonable to CURB is the conditional commitment of KCC staff and KGS to work towards a generic investigation into energy burden in Kansas. CURB has already received the commitment of KGS to work towards legislation authorizing low-income tariff relief. However, in CURB's view, understanding the extent and causes of energy burden in Kansas is an important aspect of designing relief for low-income ratepayers. When I mentioned this aspect of the settlement agreement to the board members of CURB, I got questions. Among those, why should low-income ratepayers be a bargaining chip when dealing with utilities? And why do we not have information on energy burden already? It has been a problem for decades. I could not answer those questions. I realized that CURB is not focused enough on energy burden facing many Kansas ratepayers. And I was reminded of that saying, it is easy not to recognize a problem when you choose to look the other way. I ask that all of us focus on energy burden in Kansas, as it is a significant problem. We do not understand the scope of the problem or its causes. We do not know how many low-income ratepayers are disconnected from their utility service multiple times a year. We do not know how many low-income ratepayers live in multi-unit housing. But we need to understand these and many more things. Having a portion of the settlement agreement provide an avenue to address Kansas energy burden helps to make the settlement agreement reasonable to low-income ratepayers. For these reasons I have expressed and are contained within CURB's testimony, CURB supports the settlement agreement as just and reasonable. Request that the Commission approve the same. Thank you.
Thank you very much, David. All right, let's turn now to the opening statement for the KCC staff. Mike Neely.
Good morning, Commissioners. Thank you. I'm Michael Neely on behalf of Commission staff. The Commission staff supports the settlement agreement in this matter, allowing KGS to issue securitized utility tariff bonds to recover the extraordinary costs incurred due to the February 2021 Winter Storm Uri. The terms of the settlement agreement authorize KGS to recover roughly $328 million in qualified extraordinary costs through fixed monthly charges. Staff's witness, Justin Grady, will testify to the terms of the settlement agreement and in general explain why adoption would lead to just and reasonable rates. At a high level, benefits of utilizing securitized utility tariff bonds as opposed to traditional rate-making methods is estimated to be approximately $35 million to $46 million over the course of 7 to 10 years. Staff will also explain the changes made to KGS's proposed financing order to adopt a collaborative pre-issuance review process in order to achieve the highest possible bond ratings, as well as achieve the lowest securitized utility tariff charges pursuant to the terms of the Kansas Securitization Act. There are other matters covered under the settlement agreement, including a determination regarding cost recovery for certain sales for resale customers that cannot be included in the securitized bonds, a waiver of certain billing standards to prioritize payment of securitized bonds, approval of certain transaction documents as to form, a reconciliation process regarding expenses, treatment of earnings on the capital subaccount, a customer education program, and an agreement for KGS to study whether the residential class could benefit by being separated into multiple subclasses, similar to the rate choice options for Oklahoma natural gas. Staff will also explain why the settlement agreement in this matter meets all of the elements the Commission usually considers in determining whether to grant approval. At the close of the evidence, we would ask the Commission approve the settlement agreement in this matter. Thank you.
Thank you, Michael. Well, that concludes the opening statements. Let's now turn to the examination of witnesses. The first witness will be Janet Buchanan on behalf of KGS. However, I would ask Mr. Flaherty or Mr. Vincent, would you please call your witness?
Yes, thank you, Your Honor. Kansas Gas Service would call Janet Buchanan.
Denise, if you could.
Yes, Ms. Buchanan, please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Can you state your name and business address for the record?
Janet Buchanan. My business address is 7421 West 129th Street, Overland Park, Kansas, 66213.
Who is your employer?
Kansas Gas Service.
What is your position with Kansas Gas Service?
I am the Director of Rates and Regulatory Reporting.
In that capacity, did you file testimony in support of the unanimous settlement that is the subject matter of this proceeding?
I did.
And do you have any changes or corrections to that testimony?
I don't have any changes to the testimony.
Do you have any changes or corrections to any of the attachments to the financing order that is attached to the settlement?
Yes, early this morning, we were notified by JP Morgan that a couple of changes would be helpful in the securitization process. And so I can share my screen and walk through that. The first change is on Appendix B, the form of the tariff. So just bear with me while I figure out this. Okay. Are you able to see the form of the tariff?
Yes.
Okay. So on the first page of that tariff, the table with the allocations on number 3 of the tariff was incorrect. It had not updated the changes in percentages when the sales service for resale customers were removed from the table. And so that change needs to be made there. And then as discussed with staff and Curb earlier this morning, the JP Morgan suggested that we add to the definition of revenue requirement. And I did find a easier place to put that. So down where we define revenue requirement on page 2 of the tariff, we need to add to the end of that, the revenue requirement is equal to the securitized utility tariff bond principal, interest, servicing costs, and other ongoing costs. And then the new addition is replenishments to the capital subaccount if needed. And then Appendix C, which is the form of the true-up letter. On page 1 at the bottom, it contains this same table that's in the tariff and will also be updated.
And Your Honor, we will provide those changes for the record shortly after this hearing concludes today. Ms. Buchanan, if I were to ask you the questions that appear in your testimony, would your answers be the same today?
Yes.
Thank you. Your Honor, I'd ask that Ms. Buchanan's testimony in support of the settlement be referred into the record, and I would provide her for questions from the commissioners.
So a point of clarification, if I could, Mr. Flaherty, I think I'm taking it that part and parcel of your motion here is the amended portions of the testimony. Am I not correct? We have already admitted the testimony as it was originally proffered. Is that correct?
Yeah, I think the parties elected to refer into the record as a preliminary matter the pre-filed testimony, except for the testimony on the settlement, which each witness then would sponsor, and we would move for admission at the time the witness took the stand. So it's what I'm asking the commission to admit into the record is just her testimony in support of the settlement, because the other parts of her testimony have already been admitted into the record.
All right, thank you. I appreciate the clarification. Is there any objection? Without objection, it's admitted. And I believe you've proffered Ms. Buchanan for cross-examination.
Yes, thank you, Your Honor.
Yes, good morning, Ms. Buchanan.
Good morning.
Let's turn to the commission and see if we have any questions from the commissioners. I'll begin first with Commissioner Duffy.
Good morning, and thank you for being here, Ms. Buchanan. Good to see you. I have a couple of questions. First of all, the volumetric versus the fixed. And the recommendation is for a fixed cost for the customers. But I would like to know a little bit more about securitization in other states that you're familiar with. Have they adopted, did they adopt, because my understanding is other states have already proffered theirs. Did they adopt the fixed versus volumetric?
For our division in Oklahoma Natural Gas, the commission did approve the use of a monthly per customer charge. For Texas, all gas utilities are charging the same rate. They've combined all the natural gas companies together for securitization, and they will all be charging the same rate. And that is included as part of their cost of gas adjustment. And because of that, it was necessary for that to be a volumetric rate. But to my knowledge, there is some variation from securitization to securitization on whether a volumetric charge or a monthly per customer charge is used. But the advice we had been given was that because there have been so few natural gas utility securitizations that have been evaluated, that to achieve the highest possible bond rating, it would be necessary to have a monthly fixed customer charge. there's concern about the future of the natural gas industry and the volatility that could be there in volumes in the future. And so to receive a AAA rating, it would be likely that we'd need the per customer charge.
And the AAA rating is my understanding, that is what everybody strives for.
That's correct.
Why is that so important?
That's
versus
important.
A AA.
Well, I know that it's important to receive the lowest possible interest rate, but the distinction between AAA and AA, I know we have Mr. Atkins here with us today, and he could probably provide greater insight on the distinctions there.
But is it, we want a AAA because it will give us the lowest possible interest rate? Is that correct?
That's correct. That's
Okay.
correct.
All right, very good. So let's keep on this fixed rate. Periodically, it's my understanding you will come back to the commission to perhaps twice a year, at the very least once a year, to kind of readjust. Take what you've received and make any adjustments that are necessary. So are these adjustments related to the fixed amount that the customer will be charged?
Yes, it will be twice a year. We will come in and recalculate that customer charge, that per customer charge. It'll be based on the amount of remittances we have received. So some of that will be affected by bad debt. If some customers aren't able to pay their bill or don't pay their bill, then the amount we collect will fall short of our projections. If our customer count increases or decreases, then we will project our expected revenues for the upcoming period of collection. And so that all those types of changes will factor into what the rate will be for the next 6-month period.
Do you anticipate, based on what you know now, that when you come back and recalculate, that the customer charge will increase or decrease significantly? And again, define significantly. Have you made some projections to that effect?
Because the charge is based on customer count, we think the rate will be fairly stable, but it depends on, and because the bond payments should be fairly consistent from period to period, there shouldn't be a lot of variation. What could cause variation is if there was a larger than anticipated amount of unpaid or bad debt related to customer bills where they just pay nothing on the bill and we can't make any contribution to the securitized utility tariff charge.
Have you analyzed your data of those folks not able to make payment due to the increase in gas prices over the last 8 months or so? Have you seen an increase in non-payments in Kansas?
I would say from the data that we've been providing to the commission related to the generic proceeding related to the pandemic, that in recent months we've seen not necessarily a greater number of people being unable to pay their bill, but the amount owed is higher because of the higher gas prices.
Does this cause you concern as it relates to the recalculation that will occur?
Well, given that the charge, we've requested that the securitized utility tariff charge receive priority in the, if a partial payment is made by a customer, that it receive priority and be attributed to that securitization charge, that should help address that concern.
Okay. So my understanding is time is of the essence, and the commission getting out an order if it chooses to go with securitization, because the feds have been very active in raising the rate for everyone. So how, with your expertise that you've brought in to help you with this securitization issue, how much, I mean, the feds are going to come out again next month and raise the rate, presumably, and again before the end of the year. How much of that do you believe will be a factor on the ability to get a good rate for this securitization today that we're dealing with?
Well, certainly any action by the Federal Reserve will affect the interest rates that on the bonds that are issued if we're move forward with the securitization. But compared to traditional rate making recovery, we still believe there's significant amount of room there for securitization to yield net quantifiable benefits for customers. The Securitization Act also allows the Commission to approve securitization if it believes that the mitigation to rate impacts is achieved through securitization. So if we can spread recovery over a longer period of time, we're looking at 7 to 10 years versus what we would under traditional rate making, which would be shorter, 3 to 5 years. We showed that traditional rate making, that rate impact is about $9.40 some cents a month. And if we securitize, that rates between $6 and $4.50 ish and $6. So there's still benefit there with the mitigation of bill impacts.
Okay. As you brought up the state of Oklahoma, and what are their customers paying monthly and for how long under their securitization? Do you know that?
I know that they haven't priced the bonds yet in Oklahoma, so that's expected to happen later this month. But I know that they will be paying over 25 years for the winter storm, but their costs were much higher than ours. They were like 1.3 billion. And so a more extended period was necessary to have reasonable customer impacts.
Okay, all right, thank you. Finally, my last set of questions has to do with low income discussion that by, I think you're in your rebuttal, page 6, discussing that by 12/31 of this year, looking at a tariff to assist low income. So my question to you is, do you believe that you will have a bill ready to take to the legislature for the 2023 session? And if not, why not?
It is our goal to work with CURB and staff, and I believe some other utilities are interested in participating in the crafting of that legislation, and I think we can have that ready for the next session.
Are you aware of any other states where there is a tariff for low income?
Yes, we, as my testimony indicates, we had attempted to implement a low income tariff here in Kansas that was similar to one that Oklahoma Natural Gas offers in Oklahoma, but because of our differences in statute, we weren't able to implement that here. And so that has been our main problem with moving forward with the low income tariff. And we were still looking to see if there was something we can do without a legislative change, but I don't think that's likely to be possible. But we'll keep looking and working with CURB on legislative changes.
And Mr. Nickel did just state that they do not have data on low income folks in this state. Do you as a company have data at hand that would be helpful to better understand the low income folks, where they are and what their issues are? You do.
No, I was nodding along that I was following your line of question. We don't have an easy way of looking at our billing system right now, but we are expecting by the end of the year to have implemented some changes that will allow us to be able to make easier delineations between types of customers, types of residential customers. I mean, we have general knowledge. We could look at geographic information and make assumptions, but I think with the additional kind of plug-in that we will be adding, it will help us to really drill down to specific customer level and be able to provide more meaningful information in the future.
I would just share with you that I do know the city of Topeka works through their zip codes, and they have a comprehensive map that identifies those intensive care areas. They've identified them as intensive care. They're shaded red, meaning that they meet certain criteria related to low income, probably more poverty, issues getting kids to school, paying bills, poor housing, that sort of thing. And the whole city, actually by zip code, has been and evaluated, and they continue to update that yearly. I don't think it's unique to the city of Topeka. I believe that most communities have something similar. That may be a starting point. They really, I mean, now you can determine your life expectancy from the zip code in which you live, which is a sad commentary on our demographics, but it's a reality. I personally hope that we use this time before the session starts to be able to have some drafts of legislation that staff can review, that we can give to legislative staff to share with members of the legislature. Thank you. I appreciate it, Ms. Buchanan.
Thank you.
Thank you, Mr. Chair.
Absolutely. Commissioner French, please.
With all that good ground covered by Commissioner Duffy and Ms. Buchanan, I don't believe I have any questions. Thank you.
All right. Thank you, Commissioner French. Ms. Buchanan, I'm in exactly the same position as Commissioner French. The questions that I was intending to ask of you have been asked, and you've answered them in conjunction with your cross-examination by Commissioner Duffy. So as a result, I have no questions either. Mr. Flaherty, if you wish, redirect.
No redirect questions. Thank you, Your Honor.
Very good. Well, Ms. Buchanan, I think that concludes your testimony. We appreciate your testimony very much, and you may virtually stand down.
Thank you.
Our next witness is a CURB witness, Patrick Orr, and I'll turn to Mr. Nickel. If you would, please call your witness.
Thank you, Chairman Keene. CURB would call Patrick Orr virtually to the stand.
Mr. Orr, please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Mr. Orr, your microphone is off. Mr. Orr, your microphone is off.
It's still off.
I do swear to tell the truth. I'm sorry. I had issues trying to get my microphone to come on. I apologize, sir.
Thank you.
Good morning, Mr. Orr.
Good morning, sir.
Let's turn to the commission, see if we have any questions for you. And again, I'll turn to Commissioner Duffy first.
May it please the commission, I'm so sorry, but I don't believe I have moved for admission of this testimony when in my initial motion was only as to testimony that was filed on June 17. So
Okay.
could I proceed?
Yes, please.
And I'm sorry about that. I should have done that differently, but Mr. Orr, would you state your name and your business address for the record?
Yes, sir. My name is Patrick Orr, O-R-R. My business address is 1500 Southwest Arrowhead Road, Topeka, Kansas, 66604.
Mr. Orr, by whom are you employed?
I'm employed by the State of Kansas Citizens Utility Ratepayer Board, better known as CURB.
And in what capacity are you employed by CURB?
I am a regulatory analyst, sir.
Mr. Orr, did you cause to be filed in this docket testimony in support of the settlement agreement dated July 21, 2022, consisting of 15 pages, including your verification?
I did, sir.
And do you have any revisions to that testimony at this time?
I do not.
Mr. Orr, now that you're under oath, if I were to ask you the same questions contained in your testimony, would your answers be the same as are in your testimony?
Yes, sir, they would.
May it please the commission, I would move that the testimony of Patrick Orr in support of the settlement agreement be spread upon the record.
Is there any objection? Without objection, it's admitted.
And at this point, I would tender Mr. Orr for some examination from the commission and only pray that those are really hard questions.
Well, we'll do our best. Let me turn first to Commissioner Duffy.
Thank you. Good morning, Mr. Orr.
Good morning, Commissioner Duffy.
In Mr. Nichols' opening comments, he talked about ill-begotten profits and profiteering and how that must be dealt with. And it is being dealt with at the FERC and at the Office of the Attorney General. When was the last time you received an update from either FERC or the Office of the Attorney General related to any profiteering that may have gone on?
Commissioner Duffy, I have not received a notification from either office.
So a year and a half into this, you've not been updated at all by either entity?
I personally have not. I cannot speak for others within CURB.
Okay, all right. Thank you. Let's turn to the low income discussion that I had with Ms. Buchanan, and that is part of the settlement agreement. And from Mr. Nichols' testimony, it sounds like your office will be a very active participant. Do you anticipate that there will be legislation ready for the 2023 legislative session to be considered?
I hope that legislation will be ready. I mean, I know there are other entities that will be involved in writing legislation. It must be analyzed and proofed by other offices within state government. But I would hope that there would be legislation ready for the legislative session in 2023.
As your office is part of a national group of utility ratepayer boards, are you aware of any other state that has adopted low-income legislation to assist customers in paying their bill?
I would say that I am aware that Oklahoma has a low income rate that enables assistance for low income individuals.
Do we have the commitment of your office that you will participate in the discussions and work towards getting a piece of legislation ready for this year?
Yes, ma'am, you have our commitment.
Okay, thank you very much, Mr. Orr. Those are all my questions, and thank you, Mr. Chair.
Commissioner French.
Thanks, Mr. Orr. I've read all your testimonies and appreciate the perspective of the residential customer class, but I don't believe I have any questions about it. So thank you.
Yes, sir.
Commissioner Duffy.
I'm sorry, I would like to go back and just ask on customer education, as that is part of the settlement as well. What role do you see your office being a part of in the communication aspect of when this gets loaded onto the bill?
Right now, I see CURB as being mainly serving an advisory role to help Kansas Gas Service, other utilities bring this forward so that customers are aware that these costs will be coming on their bill. CURB has a website and a newsletter that we can use to spread this information to our customers, so we can advise readers of our newsletter through the newsletter that these charges will be on their upcoming bills. We can do the same to our website. I would encourage that Kansas Gas Service and even the KCC put this information on their websites, because it's been a long time since February 2021. So it's unfortunately kind of a forgotten event. And I think it's important that we work with KGS, with the Kansas Corporation Commission, to show this information to their customers, so they are aware these charges will be coming soon.
You're right. February 2021 is now distant memory for a lot of folks, especially as the bill they're worried about right now is their electric bill, as we continue to sizzle in the state of Kansas. And don't take this wrong, but as most people don't even know you exist, they don't know we exist either.
I understand.
How are you aware of any other ratepayer boards in other states? Are you aware of any advertising campaigns they did to get this information out?
I'm not aware of that. I think, we talked about putting it on our website, and you said, well, that many people are not aware that CURB exists, but there are other avenues. I mean, the utilities use information in the newspaper. They use information on Facebook. They use information on emails. You can do bill inserts. These are things that can be done to help educate the customer.
And your office will be an active participant in helping to design the necessary information.
Yes, ma'am.
Okay, thank you. And thank you, Chair Keen. That was on a different page in my notes, so that's why it skipped it. Thank you.
All right. Mr. Orr, I'm in the same position that Commissioner French was in here. So I have no questions for you either. Mr. Nickel, any redirect?
No redirect. Thank you, Your Honor.
All right, very good. Well, Mr. Orr, I believe that concludes your testimony this morning. We thank you very much for your participation, and you may virtually step down.
Thank you, sir.
All right, our final witness is a KCC staff witness, Justin Grady. I will turn to Ms. Maslington. Yes, please. If you would, Call your witness.
Yes, at this time, I would like to call Justin Grady. Good morning, Mr. Grady.
Please raise your right hand, Mr. Grady. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Mr. Grady, could you please state your full name and business address for the record?
Yeah, my name is Justin T. Grady. My business address is 1500 Southwest Arrowhead Road, Topeka, Kansas, 66604.
And by whom and in what capacity are you employed?
I'm employed in the Utilities Division. I am the Chief of Revenue Requirements, Cost of Service, and Finance.
Thank you. Are you the same Justin Grady that pre-filed direct testimony in this docket on June 17th, 2022, and testimony in support of the unanimous settlement agreement on July 21st, 2022?
Yes.
Do you have any changes or corrections to make to either of your pre-filed testimonies today? Was that a no?
I'm sorry. Yes, I said no. I don't have it.
Okay, sorry. Is all of your pre-filed testimony true and accurate to the best of your knowledge?
Yes.
Thank you. Staff now moves, to the extent that either of these documents have not already been admitted to the record, staff moves to admit both the direct testimony and testimony in support of the unanimous settlement agreement of Justin Grady into the record.
Very well. Is there objection? Without objection, they're admitted.
Thank you. We now tender the witness for commissioner questions.
All right, thank you very much. Good morning, Justin.
Hey, good morning, Sheriff.
Kind of mix up this just a little bit here, kind of throw you off balance as best we can. We'll begin our questioning here first with Commissioner French.
Thank you. Good morning, Justin.
Hey, good morning.
I've read your testimony and, as usual, very informative, helped me understand and put all this in perspective. So the only question I think I'd like to ask here is, we heard from Ms. Buchanan earlier that I think she said just this morning they'd been in contact with JP Morgan about some tariff provisions. Is that something that they have coordinated with you on, and how do you expect that to play out?
Yeah, so yeah, good question. Appreciate the opportunity to address it. So I don't know, maybe it sounded more significant, I guess is one word, than was actually the case, but the financing order itself describes that capital sub-account replenishment process. It was just a term or a provision in the tariff that needed to be provided, I guess, for consistency and just for the avoidance of any doubt. And so, yeah, we did have a meeting with them actually this morning discussing that. And, we're in complete agreement that change needs to be made. And then, the other changes were more of a clerical issue. One of the original tables that identified the customer allocation between the customer class allocation contained that Black Hills sales for resale class, and that was identified during the technical conferences as needing to come out. Well, the line came out, but the allocation wasn't reallocated, and so it affected a few decimal points. So in this world, a few decimal points can matter. And so anyway, those were the final updates and corrections. And in terms of how I expect it to play out, it sounds like we can file errata versions of the settlement very soon, probably even before the end of the day or before the end of the week for sure.
Okay, that answers pretty much everything I'd have about that. So I appreciate the clarification and, I guess, description of the status of where you are in coordinating with the parties. So with that, I have no further questions for Mr. Grady. Thank you.
Thank you, Commissioner French. Commissioner Duffy, please.
Yes. Hi, Justin. How are you?
Good morning. I'm well, thank you.
I appreciate all the work that you all have done. I mean, this is charting new territory. for us here in Kansas. Thankfully, the Securitization Act was passed very quickly by the legislature so that we had the tool to work with. And you all have been living this nightmare for the last 18 months. And it truly is a nightmare of work. And I appreciate your efforts. I am turning to your direct testimony that you filed on June 17th, and I'm on page 15, where, and I will just read it. The question is, do these movements in U.S. Treasury rates cause you concern that securitization of Winter Storm Uri will still provide net quantifiable rate benefits for customers? Your answer is, while these interest rate movements are unfortunate, I do not have a concern at this point that these interest rate movements will fully erode the benefits of securitization for KGS's customers. Okay, that was June 17th. We're now August 4th.
Yeah.
Are you still, I mean, the word is erode the securitization. Are we still in a good place?
Yeah. So, what's interesting about capital markets and in particular the Treasury rates and the yield curve, right, is I looked this morning, and actually I think the relevant benchmark Treasury rates that we would be looking at, 7 and 10-year rates today, are probably lower than they were June 17th. And the data that I would have been looking at and referring to was put together May 27th. And so, I mean, we could look at, they might be close today that they were on May 27th. But, after that testimony was written, Treasury rates went up, 20, 30, 40 basis points. But then since then, the 10-year Treasury rate right now is down to like 2.6%. Yesterday or the day before, it was down in the 2.5 range. But it's interesting because 1-year and 2-year Treasuries are over 3%. So we have a decidedly inverted yield curve right now, where 2-year interest rates are quite a bit higher than 10-year interest rates. And so, just because the Federal Reserve raises the federal funds rate, it doesn't always directly translate into longer term rates. And so for now, it looks like we're actually a little bit better than we were a couple of months ago, which is why if you ever ask Adam or I to predict the direction of future interest rates, we won't do it. So it's now that all doesn't mean that, timeliness isn't important, and everybody fully understands the need to get this done as quickly as possible because we're in a uncertain and a volatile environment. It just happens to be that the movement in that end of the yield curve has actually been favorable for these bonds in the last several months.
Okay. Thank you. I appreciate that explanation. So the designated representative that is alluded to throughout the settlement and in the financing order, do you feel, and that is a third party that we have a contract with, correct?
Yeah, so the designated representative is meant to be a member of commission staff. And so I don't know if the commission needs to, officially designate that in an order. We didn't put it in the settlement agreement because I guess individual members of staff, could come and go. And so, but what we've identified to the parties officially is that as of right now, I'm the designated representative and Adam Gatewood is to act in my capacity if I'm unavailable. And so, that's how we have it situated now. We are advised by Foulston and Siefkin's bond attorneys, as well as Ducera Partners, which is an investment banking firm. And, you know, those guys are really good. They have a lot of relevant recent experience in securitizations. And so, yeah, I'm certainly confident in their ability to advise us and to work with KGS in order to get the best possible result for Kansas customers.
Okay, very good. I wanted you to expand on that, and I appreciate you doing that. So do you feel comfortable with I'm assuming you do, it's in the settlement, that at least once, but probably more often, there will be a meeting of the group and a recalculation?
So I think it's actually a minimum of twice a year that there will be a true up and a required recalculation. So, you know, the way it's situated is that's all very much going to be an objectively determined, pre-established, quantitatively known calculation, right? There won't be any subjectivity to that at all. We will, of course, check the numbers and make sure that there's not a data entry or some sort of a formula thing that got off. But I mean, that's, you know, securitizations that's a really important credit supportive aspect of them, right? It's you don't have to do it semi-annually, but it helps. I mean, at the end of the day, these bonds, you know, there are some publications you can read that say these bonds have a higher risk profile than the United States government treasury loans, because they, you know, once they are issued, the security to the bondholders to be repaid their interest and their principal on time is very, very high. And so, you know, I don't think we need a semi-annual true-up in this case because it's a fixed charge. So unless there's dramatic changes in the customer count of KGS, which they haven't experienced and we haven't experienced, I don't think we need it. But I guess when you're dealing with nervous bond investors and rating agencies, it just helps to have, you know, every belt and suspenders type approach that you can. And so that's why I was supportive of the idea of a semi-annual true-up. You know, the way it works is they will file it and then we will review it for accuracy within that 30-day period of time. And it'll basically automatically go into effect. But, you know, if this was a volumetric charge, then you could see pretty significant swings in that rate. But because it's customer based, you know, it doesn't matter if it's a warm or a cold winter or otherwise, you know, and also, I mean, Ms. Buchanan hit on this, but, you know, we've recommended that these securitization charges receive the highest priority in terms of partial payment. And so, you know, we're talking about $5 to $7 a month, depending on the ultimate timing of these charges. So I guess I don't see bad debt expense as being a significant risk factor that would potentially increase that charge dramatically. You know, the bigger consideration is going to be interclass movements of customers, or, you know, if we start to get into a situation where natural gas customers are, you know, significantly migrating away from natural gas as a whole, then that semi-annual true-up will come into play. But I don't expect to see the charge vary that much, to be honest with you.
Okay. Does this require commission action, or will it just happen per the settlement and the financing order?
My recollection is it just happens per the settlement, and then if there are you know, corrections or changes that need to be made, then it's addressed as part of the true-up, the next true-up.
Very good. Thank you. Again, new territory, and for the commission, this is, I think, a unique opportunity to take a situation that we could not avoid and ensure that customers benefit as much as they can, and this tool allows it. My last question to you, have you been updated by the FERC or by the Office of the Attorney General as to any nefarious activity that was taking place during Storm Uri? Have you received an update on their investigations?
I personally haven't spoken with them for a couple of months. I don't know if their attorneys have had contact with any of our attorneys, but I know that was occurring on a somewhat regular basis, but I haven't heard anything recently.
And with the Office of the Attorney General, have you heard anything as to their investigation?
So I was referring to the Office of the Attorney General.
Oh, okay.
So you know, with regard to FERC and their market manipulation investigations, you know, as we have been saying for a while, those can have a, you know, quite lengthy timeline associated with them. And what's unfortunate, I guess, about it is it's those investigations are non-public. So I don't expect any of us will hear anything until we get a report from them. Now, the FERC staff themselves, the ones that worked on the Winter Storm Uri report, for instance, we've had a couple of meetings with them, and they shared information with us, more Kansas specific information that we use to inform our investigations. But in terms of the investigation that's being performed by the Office of Market Enforcement, we haven't spoken with them.
Okay, thank you. And thank you, Mr. Grady, for, again, your staff and the work that you performed on this. And with that, Chair Keen, that concludes my questions.
All right, thank you. Well, good morning again, Justin. Let's make that afternoon, early afternoon. I'm not trying to be repetitive here or trying to put too fine a point on this one issue that I'm going to ask you one question about. But in light of Ms. Buchanan's testimony, which was pretty clearly presented, I think, I want to ask you an analogous question. Pardoning that for one moment here. In the current environment, Justin, and I'm going to give you full latitude to expand upon this to the extent you wish to do so, and I really don't want to be repetitive of any of the questions that have been asked of you heretofore, but in the current environment, could you please evaluate for us the scope and implications, if you would, of any interest rate risk that you think could be posed for this KGS securitization process going forward?
Well, without predicting the future direction of interest rates, which I won't do, you know, it's obviously been a quite volatile situation. You know, I would say that the longer term treasury rates that everything in the record's been based off of, the benchmark rates, you know, obviously have increased quite significantly over the last year or so. But they still remain, you know, in terms of historical interest rates, as you know, they're still pretty reasonable and low, right? So I was talking about the 10-year rate is at 2.6 or so this morning. You know, if you look at interest rate forecasts by, you can look at a cross section of Wall Street, and some of the most well-known and biggest investment banks on Wall Street, they are not forecasting significant rises in treasury rates through, around the period of time that these bonds are supposed to be issued. Now, that being said, just a few months ago, interest rates went up even from the time that I filed this testimony up to almost 3.5% for the 10-year. But what you read and if I had to predict, which I'm not officially doing, the projections are that treasuries would be range bound between around here and 3.5% or so for the benchmarks that we're looking at. And so, I really it'd be great if these bonds go to market and treasuries don't change from here. It'd be even better if these bonds go to market and interest rates are lower from here. But, because the situation is so volatile and difficult to predict, we stress tested the net present value of quantifiable or quantified rate benefits, in my testimony. I think I mentioned it that I added a whole another 100 basis points of interest rate movement, and those rates that we used in our scenario analyses already had a 50 basis point cushion, and there's still tens of millions of dollars of benefit to customers on a net present value basis. So, unless something dramatic happens, in other words, I mean like a doubling of interest rates of treasuries from where we stand today, or dramatic expansion of the spreads that are required for these securitization bonds over treasuries. I don't think we're going to be facing a situation where this tool is not the best one to finance these costs for KGS. I just don't expect that to happen.
Great answer. Very granular too. Thank you very much for that answer, Justin. That concludes my questions. Ms. Messenton, if you wish, redirect.
I have no redirect.
All right, very good. Well, Justin, I believe that concludes your testimony. Once again, we thank you as well for your time and effort on this entire docket and your testimony this morning, and you may virtually stand down.
Thank you.
This now concludes our hearing in docket number 22-KGSG-466-TAR. As a reminder, as everyone knows here, we have now waived post-hearing briefs. A commission order in this docket is due by September 27, 2022. However, I want to assure everyone who's a party to this proceeding this morning that the commission hears your request for expedited treatment of this matter, given the current interest rate environment and other risk factors that may be posed. We take serious administrative notice of the fact that you're requesting that an order be forthcoming before that September 27th deadline. And I think we'll do our best in-house to try to accommodate that wish. Okay, I think there really are no further matters to come. Before we adjourn, I want to thank two folks. One is our IT staff for again maneuvering all of us through this Zoom labyrinth. You've done so again in a very positive way, and we're grateful for your service. The other individual I want to really thank as well is Denise Haas. We always consider ourselves lucky, Denise, when you are willing to serve as our court reporter, and today is certainly no exception. We hope to see you on return visits many times in the near future. So thank you very much for your service to the commission.
Thank you.
Having said that, we will now stand adjourned. Thank you all.